Good afternoon, everybody. A very big warm welcome to our webinar on the new duty to prevent sexual harassment. I'm Harriet Bowtell, a Senior Associate in the team at Jones Chase, and I'm going to be hosting the webinar today. For those of you who are used to seeing Dean, he's not available today, but I'm very happy to step into his shoes today. For those of you who are new to our webinars, we're Jones Chase, the firm of specialist employment lawyers, and we act for companies from PLCs to startups and also for many individuals. So the focus for today's webinar is the new duty to prevent sexual harassment, which, as you will no doubt be aware, came into force recently on the 26th of October. And speaking today, we've got several of the Jones Chase team. So who you can see, we've got Awel, Shona, Josephine, and myself. So just in terms of the format for the webinar, if you want to ask questions, if you could please use the Q&A box, and if you want to use the anonymous button, please do so, but we'll keep an eye on the Q&A box for any questions that you have. We'll answer them as we go along if we can at the relevant points, or we'll try and get to them at the end of the session. Just to let you know, we're recording the webinar today to allow us to distribute this to those that couldn't make it at this time. And just to emphasise that the points we're covering today are not formal legal advice. And if you need any specific help, please do drop us a line. We'll be very happy to assist. And lastly, as a quick reminder, the information that we're covering today is accurate as at 12 o'clock on the 21st of November, 2024. So moving on now with what we're going to cover. So our first speaker is Awel, one of our new trainees, who's with us for 6 months on secondment. She's going to cover what the new duty is, why compliance is essential, and the potential consequences of non-compliance. I'm then going to have a look at the 8 crucial steps for compliance, which are set out in the guidance from the Equality and Human Rights Commission, which we'll refer to as the EHRC through the webinar. Josephine, one of our senior lawyers, is going to look at the practical implications of what harassment in the workplace means. So when is something that's done outside the workplace actually in the workplace for liability purposes? And given the festive period coming up, this will be something at the top of many of your agendas, no doubt. And Shona, one of our partners, will then take a look at the importance of third-party harassment being included specifically in the new duty, and also that reintroducing employer liability for third-party harassment generally is part of the employment bill that was announced last month. We're then going to have a further discussion into some practical strategies for dealing with matters including what reasonable steps actually are, engaging your staff, risk assessments, policies, and monitoring and record keeping. And as I say, we'll keep an eye on the Q&A box if you have questions as we go along. So to get things started, I will now hand over to Awel to talk you through what this new duty actually is. Thank you.
Good afternoon. As already mentioned by Harriet, I'm going to be discussing the recent changes in the law, why compliance is essential, and the potential consequences of non-compliance. So as of October 2024, UK employers are now legally obligated to take reasonable steps to prevent the sexual harassment of their employers in the course of their employment. This means that organisations will have to positively take steps to prevent sexual harassment rather than merely reacting to it if it occurs. This duty arises from amendments to the Equality Act 2010, designed to strengthen protections for employees and create a safer work environments. The preventative duty includes worker-on-worker harassment and harassment by third parties such as customers or clients or patients. And as a reminder, sexual harassment is anything of a sexual nature that violates someone's dignity or makes them feel intimidated, degraded, humiliated, offended, or like they're in a hostile environment. For example, inappropriate comments, touching, and jokes. Sexual harassment can take place in person or in other ways, such as social media, messaging tools, or email. Now, why is compliance essential? Very simply put, if employers do not comply with this duty, they're breaking the law. The preventative duty is designed to improve workplace cultures by requiring employers to anticipate how sexual harassment might happen in their workplace and take proactive, reasonable steps to prevent it from happening. The law doesn't list specific steps an employer must take, as different employers may seek to prevent sexual harassment in different ways, but all employers must take action, and no employer is exempt from the sexual harassment preventative duty. Failure to comply with the new duty exposes organisations to significant risks, including penalties from the Equality and Human Rights Commission, claims in the employment tribunals, and an uplift to compensation in successful claims. Tribunals will now expect employers to provide evidence of preventative measures such as policies, training, and risk assessments, which will be further discussed later on by my colleagues. In terms of liability, individuals may bring claims for sexual harassment in breach of the Equality Act 2010. For example, if they have suffered sexual harassment from a worker in the course of their employment. Victimisation, for example, if someone is subjected to a detriment for having made a complaint of sexual harassment. Or unfair constructive dismissal, for example, if a worker resigns as a result of sexual harassment. Compensation for discrimination, where the individual loses their job for loss of earnings, is uncapped and depends on how long the individual takes to find a new job. They can also claim an award for injury to feelings, which is not related to their financial losses, which can range up to currently £58,700 at the highest for the most serious cases of harassment. To be clear, an individual cannot bring a claim against their employer for breaching the preventative duty alone. They must first bring a claim against their employer for sexual harassment. If such a claim is successful, a breach of the preventative duty will automatically be examined. Claims can be brought against individual employees at your organisation as well as the organisation itself. Legal costs, fines, management time dealing with the issue, and potential reputational damage can have a long-lasting financial impact on your organisation. If the tribunal finds that an employer breached the new duty to prevent sexual harassment, then they can increase the awards made by up to 25%, depending on the severity of the breach. The Equality and Human Rights Commission can also take enforcement action against an employer. So it's important to remember that an employment tribunal hearing is not only financially costly, but it's usually public. So there is also the very negative public relations angle if a claim is brought and gets to a public hearing. Such reputational damage, as you can imagine, can have long-term consequences, including loss of talent, business relationships, and loss of customer and client trust. So to conclude my segment, the new proactive duty to prevent sexual harassment represents a significant step forward in creating a safer, more respectful workplace across the UK. Compliance with this law is not just a legal requirement, it's an opportunity to build a better workplace for everyone, and everyone has a right to feel safe and supported at work. If you as an employer do not deal with sexual harassment in your workplace, it can have a damaging effect on your workers' mental and physical health. This can then affect them in their personal and working life, and it just has a negative impact on workplace culture and productivity as well. The separate but equally new employment bill proposes to bring back the law which says that an employer can be liable for third-party harassment. And the Commission guidance already puts much focus on preventing sexual harassment by third parties. This is therefore a key area to consider getting ahead of sooner rather than later, and it will be discussed by my colleague later on. I'll now hand over to Harriet, who's going to talk about the Equality and Human Rights Commission's specific and helpful guidance on this matter.
Thank you very much, Paul. That's a really useful introduction for everyone to sort of understand kind of why we're here, really. Moving on to sort of the practicalities a little bit more, as you may know, the EHRC updated its technical guidance on sexual harassment and harassment at work on the 26th of September to include guidance on this new positive legal duty to take reasonable steps. And the guidance itself covers sexual harassment and victimisation. So it covers all forms of harassment and is certainly worth a read if you're looking to sort of get more information about this area. And it will no doubt be updated again as and when the law changes to provide specific legal protection from all types of third-party harassment, as Awel mentioned. The EHRC have helpfully prepared a separate and much shorter employer 8-step guide to preventing sexual harassment at work. And these steps have been taken from the longer technical guidance, but is a really good starting point when you're thinking, well, how do I actually go about that? So we thought it would be useful to go through this today. So, as Al has said, that the guidance places great emphasis on the fact that this is a preventative duty as opposed to reactionary. So this means that it's not simply going to be enough to, for example, just have a policy in place, do one set of training, and deal with complaints of sexual harassment as and when they arise. A tribunal looking at this is going to expect many more proactive and ongoing steps if they want to be able to demonstrate that they have actually taken reasonable steps. And we're going to look practically what these could be and how to implement them. And then the list in the guidance is not an exhaustive list, but it suggests that if you do take these steps, then you may well be able to comply with the duty. So I'm just going to quickly sort of run through these steps. We're going to dive into some of the areas in a little bit more detail afterwards, but I thought it'd be helpful just to take you through this so you know what certainly the EHRC would consider you would need to be doing as an employer. So step one is develop an effective anti-harassment policy. And we'll be looking at this in a little bit more detail. But essentially, an employer can have separate policies to deal with sexual harassment and other forms of harassment, or a single policy sort of covering all forms of harassment, as long as it sort of goes into enough detail. And the guidance does set out what a good policy should include. And just very, very briefly, because Shona is going to touch on this later. But again, they focus on the third-party harassment, a commitment to review the policy at regular intervals. You need to be monitoring its effectiveness and implement any changes that might be required to cover all areas of the business. And this is quite an important thing to think about if you have an international business, because you're going to want to think about covering overseas sites and subject to any sort of applicable laws that you may have in other countries. Step two is engaging your staff. And the guidance suggests that you should conduct regular one-to-ones, run staff surveys and exit interviews, and have open door policies. And the idea is that these should help you to understand where any potential issues lie and whether the steps that you're taking are actually working. And in our view, this is a really crucial point because the duty is to take reasonable steps, which is going to become, according to the Employment Bill, all reasonable steps. So seeking the views of your staff right at the outset as to where the potential risks lie and their views on what you can do to minimise them will really be a key piece of evidence when trying to show that you took these steps, provided obviously you can evidence that you considered the suggestions made and you either implemented them or explained why you didn't. And I think this is really your starting point to be able to carry out the next step, which is to assess and take steps to reduce risks in your workplace. So the 8 steps document says that undertaking a risk assessment will help you comply with the preventative duty. And interestingly, I saw the technical guidance says that an employer is unlikely to be able to comply with the preventative duty unless they carry out a risk assessment, which is actually a bit stronger. So it seems that this really is a crucial step. And when doing a risk assessment, you'll be considering factors that might increase the likelihood of sexual harassment in your organisation and the steps that can be taken to minimise them, which we'll come on to a little bit more detail later. Step 4, reporting. And the guidance says consider using a reporting system such as an online or independent telephone-based service that allows workers to raise an issue. So they can either then do it anonymously or they can choose to do it in their name if they want to. And it's really important to keep centralised confidential records of all concerns raised, whether they're formal or informal, so you can see any trends that might be emerging. Step 5 is training. And the guidance sets out that workers, including managers and senior staff, should be trained on what sexual harassment in the workplace looks like, what to do if they experience or witness it, and how to handle any complaints. And also where, if you're in an industry where third-party harassment from customers is more likely, specific training on this area. And so I think it's important to note that training really ideally should be done in person. So I think just, the days of having an online training session on its own aren't going to be sufficient. It may be good to supplement in-person training, but I wouldn't rely on just that alone. And consider having separate training for different levels of management. So managers are specifically trained on how to handle complaints. And something I think is really important is that your highest level of management really must also be included in this training, and as a way to demonstrate that not least that sexual harassment is viewed seriously by those at the top. And I imagine there may be organisations when the most senior people may be resistant to this, but I think it's really, really important, and certainly when you're looking at trying to sort of develop a different culture, if that is needed within your organisation. Excuse me. You should also have in place a process for reviewing the effectiveness of any training that you've done and be able to evidence that you have done this review. Also offer refresher sessions at regular intervals and have a timetable planned for this to make sure that you don't do a great training session and then, 18 months, 2 years passes and then you haven't done any further training, because I think a tribunal may well criticise for that. And also make sure that training is offered for new starters, so employees are also aware of their obligations from day one. So build something into your induction processes as well. Step 6 is what to do when a harassment complaint is made. And the key steps document summarises points which are dealt with in a lot more detail in the technical guidance. I won't go through this now as these points in themselves are not new and obviously could be a webinar all on their own in terms of what to do about it. But the technical guidance does give very good guidance on sort of what to do when a complaint is actually made. Step 7, dealing with harassment by third parties. I won't go into this any more detail. Shona's going to cover this a little bit more, but I think just to be aware that the guidance is saying that harassment by third parties should be viewed just as seriously as that by a colleague. And lastly, step 8, monitor and evaluate your actions. And the guide said it's important to regularly evaluate the effectiveness of the steps you put in place to prevent sexual harassment in your workplace and implement any changes arising from that. So there's little point putting steps in place if they don't actually encourage staff to report sexual harassment, and also if it doesn't actually, mean that you have less instances of sexual harassment. And you'd need to be able to evidence to an employment tribunal how you've assessed the effectiveness of your reasonable steps. So it's really important to keep a paper trail of all these steps that you're taking. So that's the 8 steps guide. As I say, we're going to look at these bits of it in a little bit more detail in due course. And I'm going to hand over to Josephine, who's going to look at the issue of something done in the workplace. I'm just actually, before we do that, Josephine, they've got a couple of questions that have arisen in the Q&A box. And the first question is, how regularly should the sexual harassment training be revisited? Shona, I think that we had a discussion about this yesterday, didn't we? And I think you had a case that you were going to mention about an analogous case about how often training should be done, if you're able to share that with us.
Yeah, so it's a case where an individual was trained in 2015, and then in 2016, 2017, there was a campaign of, it was racial harassment, where comments were made that were racially inappropriate. And at the employment tribunal, it was decided that the training in 2015 was stale and was therefore not something that the employer could rely upon in 2016 and 2017 allegations against a particular employee. So in that instance, that was a year to 18 months that it was regarded as stale training. And there was also a case where the individuals were trained in anti-harassment training. 3 months later, 3 managers were caught standing around having a right old chat, which involved acts of harassment, and a complaint was made. And it was, in that instance, the training was ineffective. So it's not only the timing, it's the effectiveness of it, which is the point that Harriet has made earlier. So how often? I would suggest that the monitoring would allow you to then decide, is this something that's having an impact on my workplace? So I'm not going to tell you every year is the right period of time, nor am I going to say every month is the right period of time. It's what you can see is being effective within your workplace, and then monitoring will show that to be the case. I suppose if you ended up having online training, It was actually, to tell you, the one that was 3 months later was online training that they said everybody ticked the boxes and answered some questions, but was completely ineffective in relation to the allegation that was in the tribunal at that time. So is anybody willing to put out a sort of every year or every 6 months or every month? I think it has to be what's relevant to you. Definitely no more than a year, I would suggest. Anyone else?
Thank you.
Particularly unhelpful because I'm not saying it absolutely should be every 6 weeks, but that's because there is no precise answer. It's what is right for your business.
Lovely. Thank you, Shona. And we had another question saying, can we have a copy of the sort of this 8 steps guide? I've posted the link in the chat box. I think hopefully everyone can see that. So it's on the Equality and Human Rights Commission website, and it's called the 8 steps guide. So hopefully everyone can see that link, which I've just, as I say, popped in the chat box. Okay, so I will now hand over to Josephine to talk about in the workplace. Thank you, Josephine.
Good afternoon. Thanks, Harriet. I'm going to be discussing in the course of employment and what that means. This is relevant for 2 reasons. First, under the Section 109 of the Equality Act, employers will be vicariously liable for sexual harassment done in the course of employment. And second, in regard to the new duty, that is to prevent sexual harassment in the workplace. So it's very important as employers to understand what is in the course of employment, what that means. And the key takeaway is it's not restricted to the 4 corners of your office or your depot or your factory. It is much broader. So what does it mean? Jones and Tower Boot Company is the leading case from 1997, where the court said, in the course of employment, should be given a purposive meaning so that it should extend to anywhere a layperson would understand to be in their employment. Simples, to quote the Meerkats. Well, it's not that simple, is it? So the courts went on and said employers will be liable for what happens in all situations that are extensions of the workplace. This is undoubtedly a sensible line to draw in the sand, but in practice, it can be very difficult to say on which side of that line a case will fall. And I have some case examples to illustrate that. The first one is in 1998, and it was a police officer, and she was sexually harassed by a fellow officer at a pub when they were off duty. And the Employment Appeal Tribunal found that this was an extension of the workplace, despite it not being at work or even in work time, and placed emphasis on the fact that the event took place immediately after work. By contrast, in the same year, another police officer was seriously sexually assaulted by a colleague at her personal quarters. Now, that's her live-in accommodation, which is provided as a part of her job as an officer. And they had met off duty, and they were not otherwise connected to one another through the force. In this case, the court found that this was not an extension of the workforce. They were no different than 2 strangers meeting in a pub. Now, I think this would have been different had they had work-related contact. In 2017, a group of colleagues went on a work-organised trip to Thorpe Park. It was on the weekend, and an assault took place between 2 colleagues. The event was attended by a mix of staff and non-staff, so the friends and family of staff who were going, as well as members of the public at large. And in that case, the tribunal found that this was not an extension of the workplace. Now, that decision was upheld by the Court of Appeal. Now, on appeal, a judgment on the facts can only be overturned by a higher court if that judgment is perverse. So the Court of Appeal could not find perversity in that conclusion, but they said something quite important, and they said on the same facts, another tribunal could have reached a different outcome. They could have found that this was in the workplace. So despite it being in a public place, a theme park, on a weekend, and a blend of staff and public, it could still conceivably have been an extension of the workplace. And I think this is a really interesting case because it shows just how broad this really can be. It's, of course, going to be difficult to plan for every situation and particularly impromptu ones. We get that. But the upshot is you need to treat all pre-planned work-related social gatherings very carefully. Under the new duty, this now requires you to assess for the risks of sexual harassment at, in, or around those events. Retirement parties, promotion parties, Christmas parties, which Harriet's already mentioned, away days. You know, we have to be really careful with these events, particularly if they are held immediately after work or proximate to work and attended primarily by staff. The fact that there's a lot of other public people there is not going to be a get out of jail free card. And very importantly, I think if there is an incident that happens outside of work, as an employer, don't say you have no obligation to investigate it. If it relates to the well-being of your staff, you do. And if you don't, you will really fall down. And I mention that because there's a number of times that I've seen cases where the employer has said, you know, this was not on our time, you know, we're not getting involved. And I think that's a big mistake. So that's the physical workplace. What about the digital one? You'll be delighted to know that this is where it gets even trickier. I think before the COVID inquiry, when the press got to pour all over Boris Johnson's WhatsApp messages, people quite rightly felt that their personal WhatsApp communications were their private and confidential business. But living in the post-COVID digital age as we do, where we increasingly work from home, like I am now, digital communication has surpassed verbal in many workplaces. As Awel mentioned, email, WhatsApp, Teams chat, Slack, these are all ways in which we interact now. And as you know, it's very possible for us to be sexually harassed over any of these forums. So this is a real risk area for most businesses that needs to be considered. Now, employers cannot monitor all of this all the time, and staff need to be trusted. And of course, they have their own individual privacy rights. So what we need to do is make sure that staff are informed. They need to be informed about the risks. And one of those risks, I think, is that their messages will not necessarily always be kept as private as they might first have thought. The Employment Tribunal Service has reported that the use of WhatsApp messages as evidence in tribunal hearings has trebled since 2019. Largely, individuals' privately held social media accounts are being used to prove that discrimination or harassment has occurred, or, for example, that certain conduct was not unwanted, i.e. that there's a chain of messages that demonstrate that banter and jokes was reciprocated between the parties, or, for example, that there was a consensual relationship at play here. From speaking to my clients, it's now really commonplace for staff members to communicate with one another socially on WhatsApp, but also for managers and their reports to use WhatsApp as a handy daily communication tool. And that's not wrong. What's right is right for your organization. It depends on the nature of your business. But for many, I found that WhatsApp is either too convenient not to utilize or already too ingrained to change. And in those circumstances, you simply need to be aware, and your staff need to be aware, that content traveling between staff members via social media can conceivably be in the workplace, and particularly where social and work issues are blended, and particularly, I think, when managers are communicating with staff. So we go back to those case examples that I took us through and apply the same kind of logic. You've got two colleagues communicating entirely privately on WhatsApp, but during work hours. This may well be in the course of employment. And so then what if those private messages continue after hours in the same chat? These are also capable of being an extension of the workplace. And I think given the way in which we as humans communicate, it's very likely that there's going to be a mix of work and non-work related content in these messages. I've got two case examples where digital communications have led to successful tribunal awards for individuals. And one was an operations clerk who was awarded £25,000 after she discovered on a WhatsApp group that she and a colleague had been racially abused. And another is a plumber who was excluded from a WhatsApp group, which was set up by the employer whilst he was on sick leave. And he was found to have been discriminated against because of his exclusion from that group was on the basis of his disability. And he was awarded more than £130,000. These are sexual harassment cases, but they're helpful for us to be alive to the fact that our messages and other forms of digital communication can be scrutinised down the line. And I know that it's really difficult to deal with these issues practically when they arise, but the starting points are: consider all forms of interaction when you're doing your risk assessments. That doesn't mean that you have the right from a privacy perspective to see or inspect or monitor private communications, but make sure you have clear policies on electronic communications and the use of social media. If you use platforms like WhatsApp for work comms, be intentional around this. Don't fall into bad habits if it's not an approved form of communication, especially for managers. And where you're using it for work, make sure staff are properly trained and understand that even private communications can come into the work sphere. Thank you.
Thank you very much, Josephine. Oh, sorry, go on, Sharon.
Oh, I was just going to ask, I wonder about the concept of a business phone and a personal phone, and whether you think we might be going back to that arrangement where we have a dedicated business phone. And so your policy that you put in place refers to that. It's used only for work purposes. So an employer can say, if something's happening on a personal phone, that clearly isn't in the course of employment, whatever time of day it is that's going on. What do you reckon? You think it might get to that extent?
I mean, I think that clearly is a helpful argument from an employer, isn't it, to show that they took reasonable steps. So I think, that may well be something to consider. Yeah, I mean, it used to be like that. There's no reason why we can't go back to that.
Yeah, exactly. So very, very interesting. Thank you.
Josephine,
oh, go ahead.
No, I was just going to say there's one question that's come in the chat, and I'm not sure whether it's actually been answered. Sharon's asked, what about people working from home that becomes their workplace? So I don't know if you've got any thought. I suppose it's talking about what happens actually in their home if that's their workplace, and what risks there might be in that scenario.
Yeah, I mean, I think that's such a general scenario, isn't it? And I think, when we are working from home, we are often communicating through digital means, aren't we? So the workspace becomes the communication between you and your colleagues and so forth. I think what's happening in your private home outside of work is likely to be outside of the workplace. Actually, Shona mentioned another sort of interesting point on this, Shona, about deliveries. Do you want to share that?
Yeah, just that this place of work is your home for a lot of individuals. And we were wondering how far that had to be taken so that if a delivery was made, and it's a work delivery, maybe it's your new laptop, whether if that delivery driver or delivery person is they're a third party, and if they say something inappropriate at the doorstep, is that harassment that's in the course of employment, because that is your place of work and it's a work laptop that's being delivered, and how liable would the organisation be in that set of circumstances? So there could be a situation where, yes, in the workplace, harassment does occur by the third party point that we're going on to talk about. It's difficult to see another example of where, other than the digital example that you've gone through in detail, Josephine, it's difficult to see any other set of circumstances. Or maybe occupational health may visit your home, and there could be an incident of harassment with occupational health. That means that I'll deal with this in the third party bit that's coming up. But if anybody's got any other ideas in relation to home-based employees, of where they would come into contact with work colleagues that could, other than digitally, that Josephine's already covered. Let's have a chat about it, because you know your workplaces better than we do.
We've got
I tend to think that if somebody is coming into your home that has been commissioned in some way by your employer, then that is more likely to be in the workplace than not, even though it's your
I agree.
home. And I think going back to the cases which we've looked at, they sort of illustrate that they can go either way. They're very fact circumstantial, but they can go either way. One little thing can kind of swing them either way. So the risk is certainly there for it to be within the workplace. And I think it's planning for that risk, which is the important aspect.
We've just got one comment in the Q&A box on this. We work for a small company and our directors own the organisation and sometimes ask someone to pick up a laptop from their home, etc. Should we allow employees to go to their owner's home? This is both in London and in Kenya. So whether or not someone should sort of allow someone into their home, that being, I suppose, sort of their workplace. But I guess that's a risk to assess, isn't it?
There's a risk associated with that for sure. And, you know, it may be that these things have to happen, but it's about putting in place steps that minimize risk. So, for example, never going to somebody's home alone. Now, it might seem a little heavy-handed to send a team of people to pick up a laptop, but I think, you know, working alone is going to be a risk factor in any sphere. And that's relevant to this scenario, isn't it?
Yeah,
I agree. I think what's useful here is that this individual has thought of an incident that could be a risk. That's exactly what you're being asked to do. Think of what the risks are particular to your business. This is something that you've identified. How can we alleviate that risk? It could be a courier. The cost of a courier is going to be far more beneficial to you as an organisation than having the individual go round to the director's place of work. Also, it's slightly difficult, bearing in mind, say that was an office person that's junior in the office. You're putting the director possibly in a difficult situation and the junior employee as to what has gone on or not gone on. And so I feel maybe you would think training is enough. Everybody's attended that training. We can show that's the case. That could not possibly have happened as you've described in relation to any allegation of harassment. Either way, one against the other. It's just try and alleviate the risk. I'd get a courier company myself.
I'm conscious of time that we should probably move on, but Shona, you're next to sort of just expand a little bit on the third party harassment point. So
yes.
please.
So third party harassment, who are these third parties? We've already identified a potential. I've already said that the courier company goes to their home and that could be an act of harassment. Would it be from the director if you're going to the director's home, or from the third party deliverer? It's somebody outside of your organisation. This all in 1996, Bernard Manning was the entertainment at a work Christmas do. And after he did his jokes and all his entertainment, he chatted to some of the waiters and waitresses that were working at that particular evening. And in his chat, he was racist and he was sexist. And two of the waiters were black female, and they complained to their manager, and they said that, and the manager was the De Vere Hotels, he worked for the De Vere Hotels, and they said that you had failed to protect us in relation to this event, and therefore it was third party sexual harassment in the course of their employment, and the De Vere Hotels were liable. And De Vere Hotels said, we're not liable. We have got no control over Bernard Manning's jokes and what he does or doesn't do, and therefore we're not liable. And the end result was within the court system, yes, the De Vere Hotels is liable because it knew that there was a potential for this risk with the jokes of a misogynistic and or racist nature. And that's what introduced this third party notion. As an employer, you could potentially be liable for the acts of another, even though you have limited control of that other. And I say limited because in the contract De Vere Hotels had with Bernard Manning, they could have added into that contract that we have this policy in relation to dignity within the workplace. This is a place of work for our employees. Therefore, please make sure that you do not crossed the line in relation to the harassment, etc. So there could have been a contractual obligation. They could have sent burden banning, their dignity at work policy at the time. In fact, in 1996, none of this really was in existence. That has all progressed as we've gone through our lifetime to 2024. So in 2010, when the Equality Act brought together all the discrimination elements within employment and the provision of services, etc., they added in a clause, clause 40, which refers to the protection of employees at work in relation to third parties. And that clause existed from 2010 until 2013, when in 2013, the Conservative government took away the third party liability. And they said it's because there are other ways that an employee of X who is being harassed by a third party, so not an employee of X, not X itself, but being harassed by someone else, they took it away because they said there's other remedies that you can rely upon. You can rely upon the prevention of harassment at work. You can rely upon health and safety, the duty to provide a safe place of work. So we don't need it. It's extra. And that's by 2013, it's taken away. And in 2013, the legislation at Section 40 just read, an employer must not, in relation to employment by A, harass a person B, who's an employee of A's. So it's just pure employment legislation. And then that has then been changed again. And the new legislation that came into place that we're all talking about from October of 2024 says that an employer must take reasonable steps to prevent sexual harassment of employees in the course of their employment. And it's thought that that's wide enough to catch third-party harassment, that it refers to take reasonable steps to prevent sexual harassment in the course of their employment. And dealing with third parties could be in the course of their employment. So that's from October of 2026. And that's why we're talking about putting this in your policies, making sure that you're clear who third parties could be within your organisation, and that those third parties are provided with copies of your policies, of what your statements, your equal opportunity views, that they're aware of that so they don't act in violation of it. But as Harriet mentioned and Awel mentioned in their talks, the Employment Rights Bill that the Labour Party has now, it's been through 2 Commons readings, it's now at the Select Committee stage. They have suggested Section 40 should read, an employer must not permit a third party to harass a person who is an employee of your organisation. And for the purposes of this section, it's you, the employer, permit a third party to harass the employee if it's in the course of employment and if the employer has failed to take all reasonable steps to prevent that third party from doing so. So rather than just reasonable steps, all reasonable steps to prevent the third party from doing that act of harassment against someone that is working for you in the course of their employment. And so that's going a step further with all reasonable steps, and it's bringing into legislation specifically referring to third parties, way back to what we had in 2010, but 2010 it was just reasonable steps. Now it is all reasonable steps. And it's getting ready now for that potential legislation. However, I will say that in the new legislation that came into effect in October, part of the suggested changes did include a reference to third-party harassment, and it was crossed out in the House of Lords, and it didn't become legislation as of October this year. But the Labour Party are hoping to get it through in this Employment Rights Bill to specifically mention. So from my perspective, I would assess within your organisation who the third parties are, what the risks are, just as the question asked in relation to the going to the director's house. That director's not a third party, but along the same lines. Who the third parties are, what the risks are, and therefore what steps you need to take to limit the liability. At the very least, those third parties must know what your policies are in relation to anti-harassment and specifically anti-sexual harassment within your workplace. And to also get, if that can be a contractual commitment, that's even better. So it's that knowledge of what it is you accept or don't accept in order to limit the risk. And I think, well, we mentioned coming up to that Christmas party time, one of the things that you have to think is the workers at the Christmas party, because there can be a flip side of this. One of your employees may harass an employee of another organisation, and your employee will be that third party who's potentially liable for the act of harassment that we've just described. So, yes, that's third party harassment.
Thank you very much, Shona. I'm aware we've got a couple of Q&As in the box. I think given time, we won't answer those now. We'll come back to them at the end. I think the question that someone's raised about risk assessment, Josephine will cover in her bit in any event. So just sort of moving on quickly, I was just going to cover briefly the question of what reasonable steps look like for your organisation, because we sort of said it's not the same steps necessarily for every organisation, but what's relevant to decide that. So it's really an objective test about what is reasonable for the employee to do in the circumstances, and it's going to vary depending on the size and nature of the employer, its resources, what risk factors need to be addressed within the particular employer or sector, as we've discussed. So I think, everybody can be thinking, okay, well, what steps have we already taken to date? What do we already have in place? And then what further steps is it practical for us to take based on, the risk assessments that we've done? And, as we've mentioned, this shouldn't be a one-off exercise. So you need to be continually reviewing whether there are any further steps that it would be practicable for you to take, thinking about whether there's been any changes in the workplace or in the workforce, the availability of new technology, such as different reporting systems, which might be available. So some of the factors that might be relevant to what steps to take are the following, and these are set out in the EHRC guidance. I thought it'd be useful to quickly run through them. So it's going to depend on the size and resources of the employer, the nature of the working environment, the sector the employer operates in, the risks present in that workplace, the nature and contact with third parties, as we've discussed, the likely effect of taking a particular step and whether an alternative step could be more effective, the time, cost, potential disruption of taking a particular step weighed against the benefit it could achieve, whether concerns have been raised with an employer that sexual harassment has taken place, and it would then be likely to be reasonable for the employer to take steps to investigate and ensure it doesn't happen again. Compliance with any relevant regulatory standards, for example, standards set by the Financial Conduct Authority or the General Medical Council, and whether steps taken appear to have been effective or ineffective. For example, if a further incident of sexual harassment occurs after steps have been taken, that might indicate that additional alternative steps should be considered. And it should also be noted that a step may be reasonable even if it wouldn't have prevented a particular act of sexual harassment from happening. And in the technical guidance in section 3.3, there's some really useful illustrations of different scenarios with employers and what steps would be reasonable in those circumstances. So I know it's very difficult for us to sort of say what specific steps you should be taking in your organisation, but have a look at those examples in the technical guidance, which will give you a flavour of specific things that certainly the EHRC thinks should have been done in any particular scenario. I'm going to move on quickly now to Josephine, just to talk about the points about engaging staff and any further points that you want to raise, Josephine, on risk assessments. And can I just, the question that was asked about this was, it's impossible to write a risk assessment for every circumstance, such as the delivery driver example. How much is an employer expected to do? Over to you.
Okay, so, I mean, in relation to that question, yes, it is impossible to write a risk assessment for every situation. What you're expected to do is what is reasonable, and Harriet's just taken us through the factors that the tribunal will consider in thinking about what is reasonable to do. There's actually an example that I thought maybe I could go through in the guidance, where it talks about, what might be reasonable in this circumstance. So in this case, it says an employer is updating its anti-harassment policy and planning training. It's a large distribution centre with most staff working in a warehouse environment. It's not open to the public, but customers can order products and attend the warehouse to pick them up from that customer collection point. The employer carries out a risk assessment. It considers what risks it has and steps it can take. And the employer implements different measures, including updates its policies and procedures, trains managers and staff, does specific training for managers to support them in dealing with complaints, has a process for reviewing the effectiveness of their policies, and a timetable for refresher training. However, the employer failed to consider the risk of its workers being sexually harassed by customers attending the premises to collect orders, despite an incident of harassment occurring 6 months ago. Now, it's interesting to sort of think, would that have been a failing if there hadn't have been this specific complaint? So kind of going back to the delivery driver scenario, yeah, you can't necessarily anticipate that delivery drivers might harass your workers. However, if this has happened to you and you know it's a risk and then you fail to do something, then, that could be a failure to take a reasonable step. It really is going to be fact dependent on your workplace.
I also think if there's an employee suggestion that says blah, 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 then you need to respond to that as well. So it hasn't happened, but actually somebody's foreseen that it could.
And that sort of ties into the point that I was going to just pick out on this. And that's around staff engagement and risk assessments. Harriet's taken us through the 8 steps of the EHRC guidance, and step 2 says engage your staff. And that talks about engaging your staff so they're aware how to report sexual harassment. They're aware of how to access the policies, where the information is, and they understand what the consequences of sexual harassment are. But going beyond just the EHRC guidance, I think that it's going to be very important to engage your staff in your risk assessments and the formulation of your proposed reasonable steps. And I just saw yesterday that the EHRC have issued some templates which are designed to assist you to navigate this process. And it's designed specifically for the hospitality industry, but I think with the view that it can be sort of rolled out. And in the commentary around these, it specifically suggests engaging with your staff on the risks. And I think that employers who do this will be in a much better place to comply with the new duty. But you're also paving the way for real workplace cultural change to happen. And the reason I think that employers who engage their staff in this way will be in a better position is because of this. If we find ourselves as an employer facing a claim for sexual harassment, this is when you have to demonstrate that you've complied with the new duty. Now, a complainant is nearly always going to be able to point to something that could have been done that was not. Does this mean then that reasonable steps have not been taken? Well, of course, it's going to depend on the facts of the case, which is what I was trying to illustrate with that previous example. But an employer who can show, we engaged with you on this, you being the proverbial you, we implemented the steps that you recognised would be helpful and we thought were reasonable. Nobody saw this coming. It wasn't a risk that you raised, so how can we have been expected to have done more? Now, I think a tribunal acting reasonably, which they typically do, will recognise this argument made on behalf of an employer who has genuinely engaged with staff on their risks. It will show that you take this seriously, you care about the well-being of your staff, and that you're willing to listen. And this is an interesting point that's come up with a few clients that I have advised on these issues over the last few weeks, is that we don't want to tell our employees how to suck eggs. We want to treat them as adults. We don't want to be overly paternalistic or patronising about these issues. But if you say, tell us where you might feel unsafe, then to me, it seems less like you're telling your staff what they already know. How do you do this? Well, the EHRC guidance, mentions things like one-to-ones and exit interviews. But, an anonymous staff survey, a questionnaire is a really great place to start. Also, what organisations or natural groups do you have within your organisation that you can have a conversation with? Trade unions is obviously a key one for those organisations that recognise unions, but what about other employee forums, women's networks, that kind of thing? What about your staff away day? Does anyone else have any other ideas about engaging staff?
I think all your ideas are great, and just in terms of that survey point, the regularity of it, because that's another thing that can go a little bit stale. So it's an ever open suggestion box that's somewhere near your sexual anti-harassment policy could be useful as well, I think.
Yeah, keeping it on the agenda, isn't it? That's
Yeah.
kind of the trick.
Yeah.
I'm just conscious of time, that we've only got a few minutes left, and Shona
Yeah.
going to say some really interesting points about policies.
Well,
So
yeah,
I don't know
I
if you
do
want to
want, yeah, let's
mention
go
those.
into policies, because
Okay.
just picking up on Josephine's point about putting everything on the list, but if it's on that list, you must do it, and therefore being careful what's on the list, that you're promising too much and you're not complying with it, or not having enough on it, and therefore haven't done enough. I was thinking, within your policy, then you can be as granular as saying, as an employee, don't leave that credit card behind the bar in work functions, because you're doing two things. One is you're creating a in the course of employment problem, and it will be in the course of employment if the boss's credit card's behind the bar paying for everything. You've then got an alcohol-fueled event that's going to maybe induce acts of harassment, and that could be a risk that you could have foreseen. And is that in your policy? You can be as granular as that, or you can leave it to responding to your risk assessment and being able to show that there's a direct correlation between that assessment, that survey, that ongoing suggestions box, and what you've got in your policy is what not to do or to do. But the things in policies, which two things I think are very important. One is how people call out acts of harassment. And at what level are you expected to do that within the workplace? Is that manager level? Is that supervisor level? Is that every employee is meant to call out every act of harassment that they hear? Or if there's a reporting procedure, that a champion that you can go to, not necessarily HR, but somebody within your team that's a champion in relation to anti-harassment. Think through what it is that will work in your workplace. But we've also had this chat over months within the firm about zero tolerance, and whether your policy should be zero tolerance or not. And we've had a chat because I was of a sort of, I'm not that keen on zero tolerance. Others are keener on zero tolerance. And actually, I realised the reason I wasn't that keen, and I should be keen, is because it's a difficult term to understand unless in your policy you have it defined. So one definition can be zero tolerance means recognising that no worker should have to experience sexual harassment at work, taking all concerns raised by sexual harassment seriously, and acting promptly to take action. That's a beautiful definition. It's from the Fawcett Society, great definition. Or it can mean any act of harassment results in dismissal. We don't have any tolerance in relation to any act of harassment. Now, it's that second definition, any act of harassment can result in dismissal, I have more of a problem with, because it doesn't take into account all the circumstances. So I'm all for zero tolerance within your policy, but make sure you make a proper definition that suits your organisation. If I can just go on to the monitoring and record keeping, but there's a reasonable steps point that needs to be covered. Harriet, do you want to go into reasonable steps?
I've already covered that, Shona. Don't worry.
Oh, okay.
We changed the order.
Sorry.
So,
I apologise that I didn't.
that's fine. It's
I'll
1 o'clock now, but we'll just
Yes.
do, if people were able to hang on just for a few more nuggets of information.
I'm
Great.
so sorry about the monitoring thing. I think the basic, you clearly have to do it. But there's one thing in monitoring, you then have to review it, and then you have to be seen to be taking taking action in relation to that monitoring. And earlier on, we had the training case where I said 3 months later, there was an act of harassment. It was found to be the training was ineffective. It's not great that an act of harassment occurred, but what a good monitoring tool is that you look at every aspect. Anyone that makes a suggestion, or anyone that says an act of harassment has occurred, and then you monitor, and then you take action, and you show that that's happening, and you let your workplace know that that has happened. And that's how the monitoring, again, I'm not going to say it should be done every month, every year, etc. It should be what suits your workplace. I must admit, anything over a year, I don't think is effective. So make sure it's more regular than that. Anybody, any comments on monitoring?
I don't think so specifically. I think we might need to wrap it up there.
Okay.
I'm very conscious we've got a few questions in the Q&A box, which unfortunately we just don't have time to answer. What I would say is if you've got a question, please drop a line to your regular Jones Chase contact. And if you don't, if you're not already sort of instructing the firm, you've got a query, please feel free to drop me a line. My email address is, look on the website, all our contact details are there. So please feel free to contact us. But unfortunately, we've had so much to talk about. We haven't been able to get to everything this afternoon. So just to finish up, say a quick reminder, the information covered today is accurate as at 12 o'clock on the 21st of November. Please feel free to spread the word to others of what Jones Chase are doing if you're happy to recommend us. And we're also happy to sign people up to our mailing list to receive free bulletins and other content if you're not already signed up to that. And lastly, just a very big thank you to our panelists today. I think it's been a very interesting and thought-provoking discussion. And thank you to everybody for attending. I hope it's been really useful, and we're really happy to those of you who are already our clients for further discussions. Those who aren't clients, please give us a call. I think this is a really important area for everybody to get right. So thank you very much for joining, and hopefully we'll see you again soon. Thank you.